Looks like our first case to come before us is N. Ray J.S. And this is a legal custody case, so the remarks that we make at the beginning of all our arguments is especially appropriate with this one. We are filming everything. It's on our YouTube channel. So please do not use the names of children or the parents or anyone else. And you each will have 15 minutes, and the appellant may split the time up to 5 minutes you can retain for your rebuttal. Just other than stand behind the podium and keep your voice up, and just stay there because we are recording. And other than that, I think that's it. Just tell me if you'd like to if you'd like to keep some time.
Thank you, Ron. Thank you, may it please the court, Andrew Karras on behalf of appellant mother. I would ask to retain 5 minutes of my time for rebuttal.
Thank you.
This case asks or presents a chance to think through the difference between a child's ideal current place of residence on one hand, and on the other hand, a child's ideal permanent custodial arrangement where the child should be charged to forever. I would submit that it's not appropriate to entirely conflate one with the other, and that you shouldn't let that first thing subsume the analysis of the second thing, and for that reason we would ask this court to reverse and remand. We have raised 2 assignments of error in this case. I'm going to address them largely together. Obviously the first assignment of error, whether the trial court should have granted the agency's request to grant legal custody to maternal aunt and uncle, has a lot of shared legal and factual overlap with our second assignment of error, whether mom's request to extend the agency's temporary custody over the child should have been extended for 6 months. So again, I'm happy to answer questions of the panel as they arise, but I'm going to address these things largely together. So as this court has described, the primary focus of any legal custody hearing is on the permanent, or on the current parenting ability of each potential custodian, and whether it is in the best interest of the child to be permanently placed in the custody of any of them. That's language I've taken from In Re KC, 2014, Ohio 372, but it's in a lot of this court's cases. Essentially, this case turns on, as we've articulated our assignments of error, disambiguating the first half of that sentence from the second half, because as mom readily conceded in her own testimony at the hearing, as it relates to the current parenting ability of each potential custodian, we don't have any dispute. Obviously, the child at the time of the sunset dispositional hearing, and for at least the short and medium term after that, was best served by living with aunt and uncle. And so, essentially, what mom has appellant is asking the court to do is unpack the second half of that sentence, what it means for an award of custody to be in the best interest of the child permanently. So this court's precedent also tells us that following a dependency determination, what's in a child's best interest is, well, disposition is made solely with reference to whether it is in the best interest of the child. Often that's a maxim, I think, used to explain why, for instance, a parent's case plan compliance isn't dispositive, or why mom or dad don't enjoy preferential treatment at the sunset dispositional stage over relatives or other third parties. And that's certainly true. I think what is also contemplated there, though, is that there are legitimate state interests, important state interests that also don't predominate. So at the legal custody hearing, we're looking at what is in the child's best interest, what is in the child's permanent best interests, absent reference to considerations like judicial economy or the agency's, again, legitimate interest in managing resource constraints. And so, turning to, I think, some of the more salient facts in this case, this is a child who is very young, who can't speak on his own behalf. Mom's work to become a suitable parent, obviously, as reflected in the case, in the record, is imperfect, but it does make a certain amount of narrative sense and a good effort, a good faith effort to become better. And so,
Counsel, isn't this the best of all worlds for this child, because it's legal custody with relatives, and mom has residual parental rights that she can obviously have visitation with the child, and it seems like aunt and uncle are more than willing to do that. So when you're talking about the best interest of the child, it doesn't get much better than that, does it?
So again, certainly with where the child should live at the time of the hearing, I think mom has absolutely no contest with what she said. The critical legal distinction, I think, between extending the agency's 6-month temporary custody and giving legal custody to aunt and uncle is that in any future petition for mom to get legal custody, she would have to demonstrate a change in circumstance that's fundamentally out of her control, either with the child or at the place of the child's residence. So legally, that's the distinction, I think, and functionally why she's asking for an additional 6 months to work on her case plan, so that she can, again, have 6 more months to essentially clean up the problems that have admittedly persisted throughout the life of the case.
And then the child was 15 months old at the time.
That is correct. At the time of the sunset dispositional hearing, I think what the court said is about a year is what the age of the child was, and I think that's the correct age. Again, just sort of highlighting some of the salient facts of the case. I think it's worth noting that aunt and uncle sought legal custody after the agency suggested it to them, is what the record reflects, and that their desire at the start of the case was to give mom and dad every opportunity to become suitable parents, and I think that again bears upon what's in the child's best interest. It bears upon the test for whether a 6-month extension was appropriate.
Counsel, regarding whether a 6-month extension was appropriate, and notwithstanding the issues surrounding who can request that 6 months, the court has to go through an analysis regarding whether or not 6 months time is going to allow for reunification. And it's my understanding from the briefs that there's some indication in the record that 6 months is not enough time for mom to complete the requirements that she would need to complete, not work on, but complete. Or that there's not much evidence that 6 months is going to, I don't want to say not make a difference, but you understand where we're going here. So acknowledging the legal argument about permanency versus temporary, what did the trial court have in front of it to show that within that 6 months, mom could complete those parts of what she needed to do to allow the child to go home on the last day of the 6th day?
Sure. So on the facts, I think there is indication that mom, however recently before the hearing, had achieved a different residence that didn't have the kinds of problems that living with dad presented. Living with dad, made a certain amount of narrative sense in mom's testimony, in that she was trying to work on a family unit with dad's father. It ultimately didn't work out, and so she moved in with a different individual. But to really credit your question, the agency certainly testified, that the agency's witnesses testified that they didn't think mom was likely to achieve everything she needed to achieve within 6 months. And as a factual finding, I as the appellant probably stuck with that. But I would just ask this court to effectuate the entirety of that statutory provision, which is that reunification is either likely within 6 months or the child is otherwise permanently placed. You know, I appreciate that like invites a question like, well, doesn't that, how do you stop that residual clause from swallowing the whole of the preceding clause? I think in a case like this where again it's a kinship placement who is local, who by all accounts is a suitable and good fail-safe resource, given that residual clause, I don't know that mom's burden to demonstrate the likelihood of reunification is an especially high one at this stage.
So, I'm sorry.
So
No,
go
you go ahead.
So is it the argument that permanency with mom, that being something in the best interest, that's the argument, was not weighed against the likelihood of what mom's status would be 6 months? In other words, it didn't factor in.
Yes, that's a way to think about it. The best interest necessarily requires an analysis of available alternatives.
Yeah, and along those lines, sort of, is, what I'm hearing in some ways is you making a policy argument. Would you explain to me why that isn't what you're doing?
Sure. So obviously the General Assembly has sort of set the bounds along which these hearings are supposed to happen, setting forth the legal standard for a 6-month extension for legal custody, et cetera, and so forth. But what they do is they give juvenile courts discretion to make these determinations, and the test is again not just that where a child is best served by living right now, and that's a factual finding that I think again I'm more or less stuck with given the procedural posture of the case, but what the child's ideal permanent custodial arrangement is, which is I would submit like a mixed question of fact and law. So with that I would reserve.
Yeah, I was just going to say, I would let you get into it without telling you because the judges were asking questions, but you will have 4 minutes left.
Thank you.
May it please the court, Kevin DiMartino on behalf of Summit County Children's Services, the appellee in this case. We are asking that this court affirm the juvenile court's decision awarding legal custody of the child to the maternal aunt and uncle and denying mother's motion for a 6-month extension. As counsel pointed out, when there is an adjudication of dependency, neglect, or abuse, and the juvenile court is going to determine whether to place a child in the legal custody of a parent or a relative, that decision is solely based on the best interest of the children, or the child. In this particular case, there's 1 child. There is no statutory scheme, so courts of appeals all across the state have indicated that the factors that we should use are the factors set forth in the permanent custody statute 2151-414D, as well as 3109-04F1. Those factors largely relate to the child's relationships with folks that they have interactions with, custody of the child, everybody who's involved in the case, their mental and physical health, if there are any indications of violence, all the things that would go to what would be in that child's best interest. And of course, if legal custody to a non-parent or a parent is in the child's best interest, then an extension of temporary custody would not. With regard to the argument about this residual clause, talking about whether it's reasonably likelihood that there would be a reunification with a parent or otherwise permanently be placed within the reunification period, that clause is in the statute that relates to dispositions that are requested by the agency. So that's in 2151.415D, and that particular section of the code says when an agency is seeking to extend the temporary custody that it has, the burden is to show if there would be reasonable likelihood of reunification or otherwise permanently placed. And that's because the agency is seeking that extension. If you read that residual clause to apply whenever another party sought an extension of custody, then the agency would always have to just have an extension, even in cases where we were not seeking an extension. Ray Casey, cited by the appellant, is a case where the agency was seeking an extension of temporary custody for a mother who was making significant case plan progress, and the agency believed that there could be a reasonable likelihood of reunification within that 6 months. So the agency sought that, which is why the agency would have that burden of showing that reunification with either the parent or otherwise be permanently placed for that child within that time period.
Is that though, counsel, because the law places the burden on the agency to get these cases resolved within a certain period of time?
That's part of it, and also because if the agency has temporary custody, we have to, within that certain period of time, just like you're saying, we have to either figure out, can the child be placed with the parent? If not, do we have a permanent option? And if we don't, we have that 2-year window where if we don't find a way to reunify with the parents or legal custody to somebody else, then we're gonna be filing for permanent custody. So that burden is on us for sure, and that particular section of the code only applies to extensions that are filed by the agency. It does not say when any other party is seeking a 6-month extension.
But then so if that's the case, then if any other party's seeking the 6-month extension, you don't have to say within 6 months it's reasonably likely.
We would have to show it would be reasonably likely that it would be our burden if we're not in agreement with their motion. So if mother's seeking a 6-month extension and the agency is not, we're, by virtue of that fact, saying it's not reasonably likely that mother is going to be able to reunify. We always have a burden of working towards permanently placing that child. I mean, that residual clause, if that applied every time mother was saying, well, I would like an extension, and we say, well, we don't think you can reunify, but we have a permanent placement option, we're always working towards one, we would always have to, a court would always have to grant an extension. Because that's
Right.
always our burden. So it's clear that that section of the code only applies when the agency has filed the motion. It would, completely undermine the ability of the agency to say, we don't support that extension, and we would be keeping the children in limbo when there is a permanent placement option that could be granted through legal custody, like in this case. This is one of those really wonderful situations. If you have to have a child that cannot be reunified, they're being reunified with family members who are working with the parents for visitation. You don't always see that. And this child was with maternal aunt and maternal uncle from the day the child was released from the hospital. So essentially the only placement that the child has had. So when you apply the best interest factors that are set forth in 2151 414D and 310904, and you look at the custodial history and the relationship with the people in the child's life, the child is well bonded with maternal aunt and uncle, the child has been in their custody and care since being discharged from the hospital. Mother has not been able to even meet the best, the basic interest factors, right? She hasn't been able to have permanent housing throughout the case. At times she was residing with father and they have a history of domestic violence. She acknowledges when she testified that she has not been able to show stable or safe housing. She indicated she has yet another residence 2 weeks before the hearing. I believe she was staying at a hotel with another individual. She has not had employment since 2020. With regard to her case plan, she also has substance abuse issues and mental health issues. She's, as of the hearing, it had been several months since she had been to see anyone at all with regard to Portage Path, and for that she only went for a medication meeting. She requires medication to deal with paranoia, delusion, and hallucinations. If untreated, those will absolutely impact her sobriety. And in fact, she has not been to counseling. She failed the intensive outpatient. She did complete inpatient. She tested positive in February for methamphetamines and then had a diluted screen right after that. So it is either the mental health or the lack of follow through with regard to substance abuse is impacting her ability to maintain sobriety. She acknowledged when she testified that she had been living with another individual within the last 2 weeks, and like I said, did not have employment, had not been able to have housing. This child who cannot express the child's own interest, their CASA guardian ad litem, testified that it was in the best interest of the child to be placed in the legal custody of the maternal aunt and uncle. So based on the best interest factors and the reading of 2151 415D with regard to the dispositional motions that are filed by the agency in these type of cases, agency respectfully requests that this court affirm the trial court's decision. There are no other questions. I rest on my brief. Thank you.
And you'll have 4 minutes.
Thank you, Your Honor. And I probably won't need the entire 4 minutes either. The one point I would, the remaining point that I would like to make with respect to the issue of standing to move for a 6-month extension, and this court has reviewed parental requests for 6-month extensions of the agency's temporary custody on their merits for decades. You've not, as I understand it, been asked to overrule any of that precedent in this case, and to the extent that you're supposed to understand the residual clause as being limited to agency requests for 6-month extensions. I think there's no way to effectuate that understanding of the clause without effectuating that understanding to that statutory subsection as a whole. And given this court's, again, longstanding practice of reviewing these parental requests on their merits pursuant to that statutory test, I would submit that that clause does not only apply to when the agency is moving for a 6-month extension. And unless there are further questions, I would rest on the basis of my brief.
Well, thank you very
Thank you.
much. The court will take the matter under advisement and issue a written opinion that will be sent to both sides, as well as the court releases our opinions electronically, and they are available on the Ohio Supreme Court website. So I appreciate your arguments, and I wish you both a good day.
Thank you.